Okay, all right. Today we'll talk about how paid family and medical leave works and how it applies to workers. As I mentioned before, now it's in advance. This is always my issue. Here we go. Both Catherine Mihalich and I will be presenting today. I'm Andrea Barton-Rees. I'm the CEO of the Paid Leave Authority, and I started last March, right before the pandemic hit. So I've been with the authority for about 21 months now. I came from HARC, which supports people with intellectual and related disabilities. And my colleague, Kathy Mihalich, is our benefits process lead, and she has well over 20 years of experience in HR. She holds a bachelor's degree from Sacred Heart in business administration and a master's degree in communication arts from the College of New Rochelle. And she and I will be co-presenting today. Today we'll be discussing exactly what the Paid Leave Authority is and what the differences are in defining for you family and medical leave versus Connecticut paid leave. We'll talk about the qualifying reasons for leave, how you can be eligible, how applications will work, and direct you to any additional resources. And then we'll have an opportunity for questions and answers. So a bit about the Paid Leave Authority. It was developed by statute, created by statute, I should say, and we have 5 primary responsibilities. Outreach and engagement, which allows us to have an opportunity to speak with you today. And we've done close to 100 webinars of all different kinds in the last year or so. We develop the policies and the procedures that are needed to run the Connecticut Paid Leave program. And we established the trust fund contribution rate, which is the 0.5% that everyone who is working for an eligible employer has been contributing to the Paid Leave Trust Fund. For those employers that wish to offer their own version of paid leave pursuant to the law, we approve and audit the private plans for those businesses that are not a part of the state plan. And finally, starting on Wednesday, we will be administering claims for paid leave benefits because you will be able to submit an application for those benefits starting on December 1st, which is Wednesday. Here are some of the key dates that workers should know. Starting in January of this year, many of you know that you have been contributing 0.5% from your paychecks to the Paid Leave Trust Fund, and that is the trust fund that is used to provide benefits when they come due in January. Starting in December, as I said, on Wednesday, December 1st, those contributing workers, sole proprietors, and self-employed individuals can start to submit an application for benefits for events that will be happening on or after January 1 of 2022. And I'll talk a little bit about that, or Kathy will later. Starting in January, those who are approved, including the sole proprietors and self-employed individuals, will begin to receive their benefits for qualifying life events. Let's talk a bit about who is covered by the paid leave law. The employers that are covered by the paid leave law are those that have 1 or more employees working in the state, and that does include not-for-profits and private sector employees that have unionized workforces. If you are a sole proprietor or a self-employed individual, you can opt into the program, but if you do so, you do have to remain in for a minimum of 3 years. There's also a residency requirement for self-employed individuals and sole proprietors. They do have to be a resident of the state of Connecticut. That is not true for employees. Sole proprietors and self-employed individuals also contribute that 0.5% of their income, and they, if they have employees, can choose to opt in for themselves, but their employees must participate in the program. Those employers that are not covered under Connecticut paid leave include the federal government, some state of Connecticut employees, municipalities, and local or regional boards of education. Again, there are exceptions there. For those that are known as covered public employees, and those are employees that work in these particular, for these particular employers, but also work in a bargaining unit. If they are in a bargaining unit, those bargaining units can vote to participate in the program. Now, as it relates to municipalities or local or regional boards of education, if the unionized workers in the municipality or the local or regional board of education vote to participate in the paid leave program, That vote is binding on everyone who works at the municipality or the local or regional board of ed, whether or not they are part of the union or a bargaining unit. Non-public elementary or secondary schools are completely exempt from paid leave because they are often exempt from family and medical leave as well. There are some other categories of workers who are exempted from paid leave and family and medical leave, and that can include some of the ones you see listed here: railroad workers, employees of sovereign nations. So if you work for the Mashantucket Pequot tribe, for example, that is considered a sovereign nation, and those that work for the tribe in the casino or elsewhere would not be part of the paid leave program, and they have their own version of family and medical leave. It also includes some folks who are engaged in interstate commerce as employees and the spouses of active military members who are continuing to pay their taxes in their home state. I spoke a little bit already about what a covered public employee is and how that works. You can see at the bottom of the slide that a municipality means any town, city, borough, district, school district. It can also include a flood commission as a municipality that would be eligible if the unionized employees choose to participate by vote in the paid leave program. So Kathy, let me know when we reach the slide where you're going to start, because I see the slides do not have numbers on them. Okay, thank you. Right. How does the 0.5% that you've been contributing to the trust fund actually work? And how is that money managed? Employees and sole proprietors and self-employed individuals contribute 0.5% of their wages to the paid leave trust fund. It is the sole source of revenue to the trust fund. This is completely employee funded. So your employer should be holding 0.5% of your earnings. They are the FICA number. So when you look at your paycheck or your pay stub, there's a box there that says FICA. They're holding 0.5% of that number. Those contributions are post-tax, and they're capped at the Social Security contribution limit, which is $142,800 as of this calendar year. Your employer withholds those wages and remits them to the Paid Leave Authority. We then validate that information to make sure that the amount that's being withheld is the correct amount. It's not too much or too little, with information that we can receive from other state agencies that also collect wage data. Then those contributions are deposited into the Paid Leave Trust Fund, which is managed by the State Office of the Treasurer. It is not managed by the Connecticut Paid Leave Authority. And then it's from that trust fund that the benefits are paid. Now, let's talk a bit about, you've heard me mention family and medical leave and Connecticut paid leave. They are, in fact, two different laws. In the law in which the Paid Leave Authority was created in 2019, changes were made to both create paid leave and to change the Family and Medical Leave Act. Many people don't know this, but there has already been a Family and Medical Leave Act, and it's existed since the 1990s. There's a federal and there's a state version of both of these laws. What they allow you to do is to take job protected time away, meaning that if you have a qualifying reason to leave, to take leave from work, and you've been working for your employer for at least 1,250 hours and 1 calendar year, meaning 12 months, they don't have to be consecutive months, just 12 months, then you were eligible to take state FMLA. But whether you took state or federal FMLA, that leave was always unpaid. Some employers would let you use your time to cover it, and many would require you to use some of your time to cover it. This will change significantly starting next year. So here are some of the changes to Connecticut Family and Medical Leave that will apply to you. If you worked for an employer that had 75 or more employees, then you were already working for an employer to whom both federal and state family and medical leave applied. Starting in January, it will apply to employers with 1 or more employees. So that's a much bigger change and a much larger population of employers that are covered now by family and medical leave. And now, in order to qualify for it, you don't have to work that 1,250 hours for state or 1,000 hours for federal, or those 12 months. To get FMLA, you have to, with a job protected leave, meaning you get your job back after you come back from FMLA, You now only have to work for your employer for 3 months. They can still require you to use your PTO while you're away, whether it's vacation or sick, or it's a paid time off bank, but they have to now let you keep up to 2 weeks. And you'll see there's an example there. If you're having surgery, you need to be out for 4 weeks, and you've got 3 weeks of accrued PTO. Your employer can ask you and also require you to use 1 week of time to cover the time you're away, but they can't require you to exhaust all of the time that you've accrued. So let's contrast that to, let me go back. But yeah, let's contrast that to Connecticut Paid Leave. We use CTPL to refer to the law itself, the program, and those of us who work at the agency that administers the programs. It is only a source of income replacement when you go out on FMLA. We do not provide job protection. And there are different criteria for eligibility for CTPL than from FMLA. So let me explain that a bit. If you, for example, are going on a leave under FMLA, but you've only been with your employer for, let's say, a month or so, and you have earned enough money to qualify for paid leave, you have a qualifying reason, you can go to your employer, you can say, I need to take time off. I know I've only been here a month, but I need to take time off because I need to have major surgery. Your employer can say, that's fine, you haven't earned enough time, your job is not protected, but if you otherwise qualify for paid leave, you can apply to the Paid Leave Authority. But we always really encourage people to have this conversation with their employer because we do not provide paid leave. Paid leave does not provide job protection. There are a number of qualifying reasons that you can use to apply for paid leave and to receive benefits. The one that's most popular and most people know most commonly is the medical leave. So medical leave is taken by a worker to receive treatment for your own serious health condition or for someone else's serious health condition that is one of the people who are covered under the statute. You can also serve as an organ or bone marrow donor, and as pregnancy is considered a serious health condition, and medical leave can be taken under FMLA and paid leave for that kind of leave. Bonding leave is the ability to take leave so that you can enjoy the emotional and physical attachment that occurs between a parent and a child. It is available for mothers and fathers, same-sex couples, doesn't really matter. It's available for parents. It can be taken at any time in the 12 months after the child has either come into your family through birth, adoption, or foster care. Caregiver leave is the ability to take time off to offer physical or psychological care or comfort to a family member who's experiencing a serious health condition. And this can mean you're taking someone to dialysis, to other kinds of treatment, chemotherapy treatment, and you are their person who takes them back and forth, who sits with them and cares for them while they're receiving the treatment, and even afterwards, as an example, when they return home after the treatment. Other qualifying reasons for leave include family violence leave, and that can be taken off by a person who is a victim of family violence for all of the reasons you see there, to get medical or psychological care, to access services from a victim services organization, to go to court, to find housing. Our state already has a 12-day per calendar year family violence leave law, but people weren't able to access it and be able to get paid or seek wage replacement, and that will change starting next year. There are two types of leave that are available for those who are serving our country. The first is qualifying exigency leave, and that's available for people who are being deployed overseas. And it allows the person who is supporting that individual who's being deployed to take time off to help them put things in order, whether it's childcare or banking or mortgage or anything else. If they're being called up to federal active duty in the armed forces, then a person can take qualifying exigency leave to engage in certain activities related to the person who's being deployed. Finally, we have military caregiver leave, and this is available for those who are taking care of those who have served our country and that person has been injured during active duty. This is a physical injury. It could be a psychological injury as well. If a person needs to take that leave in order to care for the other individual, that is available Up to 26 weeks of leave is available, but only 12 weeks of leave are paid. And the same is true for the qualifying exigency leave. 26 weeks of leave can be taken, but only 12 of those weeks are paid. Kathy, how are we doing?
We're getting close.
All right. So let me speak a little bit about caregiver leave. Right now, our statute, if you were to take family and medical leave today, it is limited to taking it for a parent, a spouse, or a son or daughter who's under the age of 18, or if they're over the age of 18, they're taking it if that person has a disability. You are not able to take it if you took it today for your sibling, your grandparent, your grandchild, or anyone you consider family. That is going to change starting in January. You'll be able to apply for, and if you otherwise qualify, take family and medical leave for all of the categories of family that you see listed here, including someone who is related to you by blood or affinity. This is called related by affinity. And what it means is what we see here. It's any person with whom the employee has a significant personal bond that is like these relationships that are listed in the statute, and they're able to prove that. So if, for example, you are living with your significant other, you are not legally married, but you've been living together for 20 years and you've raised children together and you're the beneficiary on one another's life insurance and the like, and you need to care for that person because they're experiencing a serious health condition, you would not be able to do that today, but starting in January, you would be able to do that. And example one is very similar to that. An aunt or an uncle who relies on you, you see them as a grandparent or a parent, that's the kind of relationship you have with them. You would be able to apply for leave and with the appropriate documentation, have an opportunity to take leave and to care for them as if they were related to you by blood. So here's a summary of the eligibility requirements for the different types of leave. You heard me mention that there's federal FMLA. That means you need to work 12 months for the employer. It doesn't have to be consecutive, and at least 1,250 hours immediately preceding the time that you're taking your leave. Starting next year, as I mentioned, 3 months to get job protected leave, no hours worked requirement. But to get your income replacement, your wage replacement, you do have to meet some other criteria. You do have to have earned at least $2,325 in the highest earning quarter of the last 4 or 5 that are completed before you apply for benefits. You have to be working in the state. Does this mean physically working in the state? Sometimes yes, sometimes no. Physically working in the state, some of us are still working remotely, but if you're working for a Connecticut employer and they're paying your unemployment insurance and your payroll taxes, for example, in Connecticut, you're considered a Connecticut employee, even if you're working remotely from Rhode Island. Or if you're a sole proprietor or a self-employed individual and you've opted into the program and you're a resident, remember they have a residency requirement, then you could apply for income replacement. And how much do you get? How long is your leave? Federal leave, 12 months in a 12-month period. As I mentioned before, up to 26 weeks for military caregiver leave. Remember, federal leave remains unpaid. There is some talk about paid federal family and medical leave, but nothing has been solidified as yet. For Connecticut FMLA, the job protected leave, I'd mentioned earlier, it's 12 weeks in a 12-month period, so now it matches the federal. 26 weeks for caregiver leave, 12 of those can be paid, 12 days for family violence, and there's a possibility of getting an additional 2 weeks if you are incapacitated during your pregnancy. And the same lengths of leave that you can avail yourself of for job protected leave are also available to you for income replacement starting next year. Maybe Kathy is a good place to transition. There we go. And so now I'd like to introduce my colleague, Kathy Mahalik, who's going to speak to applying for the paid leave benefits. And Kathy, I will advance the slides for you at your direction.
All right, thank you, Andrea. Good afternoon, everyone. I hope everyone had a wonderful Thanksgiving and a great weekend holiday. We're going to talk about applying for Connecticut paid leave benefits. Next slide, please. So here we have, we are on the Connecticut Paid Leave website. And you may or may not have employees coming to you. Employees may apply for paid leave and then come to you, come to the HR department, go to their employer to let them know they plan on going on a leave, or they might wait until after their claim has been approved. In either case, if an employee comes to you, what happens is that they need to create an account with Connecticut Paid Leave. There is a little red arrow pointing on the sign-in button on the Connecticut Paid Leave portal. That would be the homepage at connecticutpaidleave.org. Next slide, please. So here's what's happening effective on December 1st. Connecticut Paid Leave will begin accepting applications for absences happening on or after January 1st, 2020. So what that means is that employees may be applying for benefits during the month of December. However, benefits will be paid beginning January 1st. Claims will be submitted, may be submitted during the month of December, and payments will not begin prior to January 1st. The fastest way for employees to apply for benefits is through the online portal. However, we will also be accepting applications via mail, email, fax, or phone. The online portal will allow employees to view the status of their claim, check payments for their claim, add time to an existing claim, upload any required documents for your particular claim, message your particular case manager, or view any correspondence you may have received from the third-party administrator, which is AFLAC. Next slide, please. So let's talk about what an employee has to do to create an account with Connecticut Paid Leave. Once they go to the Connecticut Paid Leave site, they will be required to select a username or password. What they would have to do then is, if they don't have this information already set up, there is a button at the bottom that says sign up now. Next slide, please. So on the right-hand side of the screen, this is the information that the employee will be viewing once they log in to set up their account. Information such as first name, last name, the username of their choice. Very important to have an email address. They will be asked to confirm the email address. Also include a mobile number, preferred language, and they will be asked to select and set up a password. They must have an email address so that if there's any type of correspondence that Connecticut Paid Leave may have with the employee, but most importantly, once the employee sets up the account, they will be sent a verification code to their email address to be able to go to the next step of the process. Thank you. No, that's fine. You'll be able to see on the next page, after someone puts in their name, address, and all their information, they will be asked, there'll be a checkbox at the bottom saying, I am not a robot. They will be required to check that box and then hit submit to be able to go on to the next step. So this is where they would receive the verification code, which would go to their email address. So it's very important that they have an updated, correct email address when they're going through this registration process. So once they get the verification code, they go to their email and they see the verification code, they put that verification code in, and then they hit the verify blue button at the bottom of the screen. Once they do that, then they will receive a message indicating that they have successfully set up their Connecticut, their CTPL account, and that they can sign into their account at this time. Next slide, please. So you will know that you are signed in because in the upper right-hand corner, now when you go to the Connecticut Paid Leave site, their name will appear in that blue box that originally had said sign in. Now it's going to have the individual's name in that particular area. Next screen, please. So there's different types of leave that an individual could take. An individual individual could take what's called a block leave, which is a continuous absence for a single qualifying reason. So say, for example, you need to have ankle surgery and your doctor says, okay, you need to be out for 3 weeks. That's considered a block leave because it's for 3 straight weeks for the one particular qualifying reason. A reduced schedule leave is a leave that reduces a worker's usual hours that they work from full-time, let's say, to part-time, or, it could be 3 days a week versus 5 days a week, whatever the doctor recommends for whatever the reason for the leave. The intermittent leave is separate non-consecutive time periods rather than a single span of time for a single qualifying reason. For example, I've seen intermittent leaves where if people suffer from migraines and they need an hour on Tuesday and all of a sudden they have a flare up and they need 2 hours on Wednesday. Intermittent is that it happens over a period of time, but you really don't know what particular days or hours that the intermittent leave will take place. Next slide, please. So the application process. Once an employee registers online with the Connecticut Paid Leave site, there will be a button that will come up and ask them if they want to continue on to submit their claim. So what that will do is once they hit that button, they will be connected to the AFLAC portal and they can begin the process of submitting their claim. So the worker has to submit all the required documentation depending on the leave that they're taking. And then there's also what is known as an employment verification form, which the employer must complete and return to AFLAC. It's a very important form. AFLAC will review the paperwork submitted, determine eligibility. If there are any documents or information missing, AFLAC will reach out to the worker for that information. And if AFLAC does determine that the worker is not eligible, say they didn't provide the correct documentation or something, the earnings were not met, the employee will be notified. They will receive communication from AFLAC indicating that the claim was denied. In addition, the employer will receive an email whether a claim is denied or approved. An email will be going to the employer. Now, I must make a note that on the employment verification form, it is critical that all employers provide a contact phone number and a contact email address information so that we can correspond with you, or AFLAC can correspond with you as far as the status of one of your workers' claims. So once all the documentation has been received, everything has been ironed out, AFLAC then calculates the benefits. Here are 2 examples. If someone makes minimum wage, let's say, they'll receive typically 95% of their typical weekly earnings. Say someone makes $13 an hour, which is the current minimum wage, times 40, it's $520 a week, and 95% of 520 is $494. So the worker would receive $494 per week. If a worker earns more than minimum wage, there's a slightly different calculation, and the benefit is capped at a 60 times minimum wage. AFLAC issues the benefit payments. The worker can elect to receive their benefit payments by direct deposit or by a Visa debit card. Payments are made 2 weeks in arrears. What that means is, let's say someone's eligible January 1st, the first week of January, for benefit payments. That first payment will be made on January 18th. Payments are made every Tuesday. Next slide, please. Formula for Connecticut Paid Leave benefit calculation. Again, this is similar information as to what we described in the prior slide. If the worker earns minimum wage, The benefit will be 95% of their covered workers' base earnings. So minimum wage, 40, if a person works 40 hours a week, 40 times 13 is the 520. If a worker earns more than minimum wage, we take 95% of 40 times the minimum wage, plus there's an additional calc, 60% of the difference between the amount of the worker's base earnings and the Connecticut minimum wage, multiplied by 40. So for this example, it would come out to 60 times 13, which is $780 a week. How much will you receive? One of the great tools we have available on the Connecticut Paid Leave website is the benefits estimator. So if someone wants to go to the benefits estimator and calculate an estimate of what their benefit would be on Connecticut Paid Leave, we have this tool available. So scenario 1, worker earns minimum wage times 40 hours, $520 a week. Benefit is 95% of that amount. We have $494 as the weekly benefit. Next slide, please. Same example for the person who earns above minimum wage. They can also use the benefits estimator. The worker works, say, 40 hours a week at $15 an hour, which comes to $600 weekly. The calculation is 95% of the 40 times 13 plus 60%, come up with $542. So worker B would receive $542 a week in benefits. How does Connecticut Paid Leave work with employer-provided benefits? The employer may require or may permit a worker to use any sick or other paid time off while on an approved leave, provided that a worker who's taking leave pursuant to Connecticut FMLA must be allowed to retain 2 weeks of such paid time off. What that means is effective 1/1/22, for an individual taking Connecticut FMLA, let's say, for example, an employee has 3 weeks of vacation and they want to use some sick time or vacation or PTO time towards their time off. It is required effective 1/1/22 that the employer retain 2 weeks. In the example I just provided, say they have 3 weeks of vacation or PTO. You need to keep 2 weeks of that PTO for the employee, and they could only use the 1 week towards the Connecticut FMLA. And that's a change going into effect January 1 of 2022. So here we have 4 different scenarios to provide you with examples as to how to handle different PTO requests. Let's say in scenario 1, the worker does not receive any PTO from the employer. They would be eligible for the full amount of Connecticut Paid Leave benefits for the full period of their leave. What that means is that day 1 of their approved Connecticut Paid Leave, they would be paid by Connecticut Paid Leave or by AFLAC, who processes our claims, for their benefits. Scenario number 2, worker receives employer-provided PTO equal to the amount of their regular wages for the full time that they're out on leave. Some employers offer 100% PTO for employees who are out on any type of leave. In that scenario, the worker would not be eligible to receive any Connecticut Paid Leave benefits because they're being paid 100% by their employer. Scenario number 3, the worker receives some employer-provided PTO that's less than their regular pay while on leave. So the worker is then eligible to receive Connecticut Paid Leave benefits when their leave begins, but the amount will be reduced to ensure the total compensation does not exceed 100%. Scenario number 4, the worker received employer-provided PTO that's equal to the worker's regular pay for a portion of the time the worker's out on leave. The worker would then be eligible to receive the full amount of the weekly Connecticut Paid Leave benefit, but the benefits would not start until the worker stops receiving the employer-provided paid time off. Next slide, please. So, if you're trying to figure out what benefits employees or workers will receive, They'll be coming to their employer, and the first thing that they'll probably want to know is, what type of employer-provided paid time off am I eligible for? As the employer/HR department, you need to notify the employee or the worker as to the rules as to taking such time off, such as sick time, PTO, caregiver leave. And also, very importantly, if your employer offers a short-term disability policy that you've elected to participate in, whether the policy states that the worker must exhaust all employer-provided PTO and Connecticut paid leave benefits before they can start short-term disability benefits, or whether the short-term disability policy will reduce the amount it pays for any Connecticut paid leave benefits, PTO, or similar benefits received. I would highly recommend that all employers, all HR departments review their short-term disability policies so there's a better understanding as to how these policies interact with other benefits such as CTPL and any employer-provided PTO. Your responsibilities as a worker. Your responsibilities as a worker when applying for Connecticut paid leave. The employee would notify their employer that they want to take a leave, and they would begin a claim with Connecticut paid leave. If they want to apply online, they would go through the steps that we talked about earlier. They would go to the ConnecticutPaidLeave.org website, and they would set up an account, register for an account. And once that process is completed, then they can file the claim online. Once AFLAC has the claim, once they've received the claim and it's being processed, the case manager assigned to that particular claim will provide a list of documents that the person may need to provide for their leave. So whether it's a medical certification, adoption paperwork, military orders, all the requested documentation must be provided in the time frame indicated. Also, the AFLAC case manager must be notified of any changes. Let's say, for example, you originally submitted, or the worker originally submitted for a claim for January 1st, and now they find out, oh, there's been a change, and now I don't need to take my leave until January 20th. That would be something important to let your case manager know, as your start and end dates for your leave, in addition to any PTO, any short-term disability benefits, everything would be affected if there was a substantial change like that to your leave. Next slide, please. Process for Connecticut family medical leave. Notify your employer about your need to take time away from work in a timely fashion. 30 days in advance if the leave is foreseeable, and as soon as possible if it's not foreseeable. As soon as possible when someone has an emergency, as soon as possible, maybe a day or two before, depending on the typical, depending on the situation. Your employer has 5 days to notify you if your leave is eligible for job protection. Please note, this is not the approval process, and they will let you know, your employer will let you know if they need additional documentation. You have 15 calendar days to provide the required documentation as requested by your employer, such as medical certification from your doctor, military documents, adoption records, etc. If you have difficulty obtaining any of the required documents, let's say your doctor's on vacation for a month, or you need more time to get the adoption records, your employer may provide an additional 15 days if you have trouble obtaining the required documents. Once your employer has receipt of all documents, they have 5 days to notify you if your request for job protected leave has been approved. The employer should notify you if you're required to use your PTO accruals, how and when you need to report in during your absence, which is, do you report it to a supervisor? Do you contact the owner? Do you contact HR? And if you would need to provide a fitness for duty before your return. Your employer is responsible for tracking your leave usage to ensure you don't exceed the 12-week limit. And you should notify your employer of any changes to your leave. If somebody returns earlier, or if they need to extend the leave, those are examples of when the employee should be going to the employer to notify there's been a change in the leave that I'm currently on. Remember, even when you are approved for Connecticut and or federal FMLA, you must always follow your employer's attendance and call-in policies. You will need to notify your supervisors when you're taking your FMLA leave. You're responsible for providing your employer with complete and sufficient medical certifications. For example, if a medical certification is submitted but it's not signed by your doctor, it will be rejected. There may be other laws beyond Connecticut FMLA that apply to your situation and can't offer job protection, such as federal FMLA, which applies to companies with 50+ employees, Americans with Disabilities Act, which applies to companies with 15+ employees, Pregnancy Disability Act, which applies to companies with 3+ employees, Connecticut Fair Employment Practices Act, which applies to companies with 3+ employees. And also there's workers' compensation for on-the-job illness and injury, which can also provide income replacement benefits. Please note, if an employee is receiving workers' comp, they are not eligible for Connecticut Paid Family Leave. For some reason, sometimes employees don't want the leave to be designated as FMLA. They just want, I just need to take some time off, or I just need to be out for a while. In all circumstances, it is the employer's right and responsibility to designate the time off that qualifies under FMLA as FMLA leave for job protection. Andrea?
Muted myself, I'm here. Back. Thank you, Kathy.
You're welcome.
There are additional resources. I know that Kathy and I covered a lot today, but there are ways that you can get this information. First of all, everyone who is attending will receive a copy of the presentation for your own reference. And there is a place on the website, if you go to process, and then you pull down on that menu, there is a page for employees where there's a lot of information. You can join our mailing list, and we have a number of frequently asked questions. We do not have a call center, and I know this is a source of frustration for people, but they are extremely expensive. And as I said when we started, we only have one source of revenue for everything that we do at the Paid Leave Authority. We want to maximize that so that there are adequate resources for benefits payments. If you have a question, you can use the contact feature on our website, and we have a wonderful team at United Way that will respond to your questions, usually within 24 hours, usually within the same day. We're here to help you. As I mentioned, use the contact feature on our website, ctpl.org. We have a lot of frequently asked questions and helpful videos and documents and tools like the benefits calculator that Kathy demonstrated or showed you earlier. Again, our website is ctpl.org, and we really appreciate the opportunity to share this with you today. And so let's just see if we have any questions. All right. So I see we have one that asks about what we call in-flight claims. So claim begins in January and prior to January. Kathy, do you see this one? Would you like to take this one and then I can take the next one?
Sure. So the question is, if someone begins a leave prior to January 1, can they start a claim for the portion of the leave that begins after January 1? For example, someone goes out on disability 12/1 and they're anticipating that they're going to be out January 31st. Are they eligible for CTPMFL or not, since the leave began before 1/1? Very good question. Connecticut Paid Leave, CTPL, employees can start applying this Wednesday, effective 12/1, for being out January 1. For Connecticut, now when someone says Connecticut PFML, I'm looking at that they're referring to Connecticut Paid Leave. Those benefits don't begin until 1/1/22, so they would not be paid for any benefits in December.
Correct.
It would be 1/1/22. The benefit payments begin.
Yes, that's correct. So even if their leave starts this year, as Kathy said, it would only be eligible for benefit payments starting next year when the law changes. So the next question is about a unionized workplace. So for a union represented workplace, if the employees vote for participation, is the voting body the number of the members in the union or the number of employees actually voting for and against the program to determine a majority decision? This is an excellent question. The statute does not answer this question at all. But we know that in private plans, when someone, and so we're using this corollary, when someone votes, if an employee, let me put it a different way, in the context of private plans, the majority of the employees have to vote for the plan. But that doesn't necessarily mean that the person is in a unionized workplace or not. So we're talking about a workplace that is a municipality or a local or regional board of education. That's the only time where the voting in the bargaining unit matters. If you are working for a private employer and your private employer decides that it wants to operate its own private plan, the number of the voting body consists of all of the employees, whether they're in a union or not. So that's what can get a little bit confusing. So private employer has a lot of bargaining units. The number that we're counting on to determine whether or not there's a majority who will participate in a private plan is everyone who works there who can participate. If you're working for a municipality or a local or regional board of education where the bargaining unit can opt to opt in, it is the majority of the people in the bargaining unit. That's the voting body number, okay, to determine a majority decision. Because the other folks won't necessarily have an opportunity to vote because it's really driven, they are by statute excluded from the program unless the bargaining unit chooses to participate. So the voting body is the members in the union. Then I see Natalia has a question. Does the authority contact the employer when an employee applies for CTPL or regarding other pay? Kathy, did you want to answer this one?
Yes,
Okay.
please. Thank you, Andrea. Natalia, what happens during the claim process? There is what is called an employment verification form. It's a very important form for employers to complete. The employee is required to complete the top portion of the form, and then there is an entire section for the employer to complete, which includes questions about the employee's date of hire, their position, their hours worked, their schedule, their pay, their wages. So that the questionnaire that you will receive, the form you will receive, the employee will hand you and give to you as part of the CTPL process. And as of 12/1, what's going to happen is that employment verification form will be available on the Connecticut Paid Leave site under the employer section. It'll be a blue button on the form that you can view that form ahead of time before employees come to you requesting that possible information.
We have another, Natalia says, thank you. You're very welcome. It's our pleasure
You're welcome.
It's our pleasure to answer questions. I don't see any others in the chat right now. And we are almost at 5 o'clock, but if you have any other questions, we can give you 10 minutes back, set on a Monday after a long holiday weekend for most of us. So I know there's probably a lot to do. And we really appreciate the time that you've taken to be here this afternoon to participate in this webinar. Amber, if you're still there, if you wanted to just share some of the logistics of the post-webinar process.
Sure, thank you, Andrea. So everyone who's attended will receive a copy of this presentation deck as well as a link to the recorded webinar. So you can share those with whoever you would like to. You'll usually get those within the next day or two from me. And those videos are posted on YouTube. So be on the lookout for that. And I will be sending those to your emails that you registered for this webinar. Thank you.
I think that's all. Thank you everyone for your time and have a wonderful afternoon and evening. Night.
Thank you, everyone.